We have finished with the equity part of equity in trusts, and today we're moving on to trusts. And we start with a general introduction to trusts. Before that, we will look at how the concept of a trust evolved. The basic concept of a trust came about during the Crusades, which took place between the 11th and 13th century, when knights would go on lengthy military campaigns abroad. But because they'll be abroad for months or maybe even years, they needed someone to look after their land while they were gone, to make sure that everything is in order. So what they would do before they go abroad is to transfer ownership of the land to someone they trusted, usually a relative or a close friend, to manage the land until their return. Now, the risk is this was the only way they could do it. If they were not there in person to manage the land, the only way to do it is to transfer the land so that the person who now owns the land, holds the land as legal owner, is able to manage the land. So the risk would be, at common law, only the rights of the legal owner is recognized, and the knight who had transferred the land in the first place to this person would have no legal way to ensure that his family was taken care of in his absence, or that he would actually get his land back. It all depends on whether the person he transferred it to is trustworthy or not. So to solve that problem, equity came up with the concept of the use, USE. So the use is where A owns land at common law, meaning A will hold the legal title, and then B has the right to use the land in equity, hence the use. So this allowed for two separate rights existing at the same time over the same piece of property. So A holds the land, but not for themselves. They instead hold it for the right for B to use the land, and this right is recognized in equity. So this concept of the use is the earliest form of a trust. And then from there, it evolved into the type of trust that we know of today. So looking at what a trust is, in the diagram on this slide, the settler is the person who has created the trust. So the settler is the person who originally owns the property, and the settler decides, I want this property to be held on trust. So what the settler would normally do is to transfer the property, the trust property, to certain people to hold a legal title, and these people are called the trustees. So the trustees hold a legal title of this property that's now been transferred to them by the settler. As to what the settler needs to do, the formalities and so on for a trust, we're going to look at in later lectures. Okay, so the trustees will hold the trust property, they hold the legal title, but that's all they have. They only hold the legal title, meaning their duty is to look after the property for the beneficiaries. So the beneficiaries are the persons named by the settler to benefit under this trust. So the beneficiaries are said to hold the equitable title or the equitable interests. Sometimes in textbooks you will see the phrase beneficial interest. It's the same thing. So beneficiaries' interest under a trust is equitable in nature because they don't hold a legal title. It's only recognized in equity, so it's called an equitable interest. But you can also call it an equitable title, Or another phrase is beneficial interest. It's the same thing. Okay, so what we've seen here now is, as soon as property is subject to a trust, meaning that property has been transferred to trustees to hold on trust for beneficiaries, the legal and equitable title to that piece of property separates. So the legal title stays with the trustees, and the beneficial or equitable title passes to the beneficiaries. So this is important. This mental exercise is important. Every time you learn, okay, there is a trust here. What is the property? Right, it's this house, let's say. Okay, so as soon as you know, okay, a trust has been set up and this house is being held on trust, then you do the mental exercise of, right, who holds the legal title? So you need to identify who the trustees are. This person or persons will hold the legal title, but they're not entitled to benefit from the house. Instead, because this is a trust, there will be beneficiaries who has been named as the person or persons entitled to use, to benefit from the house. These are the beneficiaries, and they hold the equitable title or the equitable interest or the beneficial interests, right? Why do we have trust? What is the purpose of a trust? Well, there are many and they're varied. Examples that we will come across in this course would be a trust of land. So anytime land is held in a co-ownership, a co-ownership just means more than one person owning the same piece of land. That's a co-ownership. So you can have 2 people, 3 people more owning the same piece of land. Every time you have more than one person owning a piece of land, then a co-ownership of land is created. And anytime there is co-ownership of land, these people hold the land on a trust of land, and this trust is implied by statute. As to what an implied trust means as opposed to an express trust, we're going to look at in the next chapter, okay, in the next topic. A trust is also implied when a person dies. So when a person dies, their whole estate will pass to the executor of the estate. So when a person dies, normally they would have executed a will. So in executing the will, they should also have nominated someone, one or more persons, to act as the executor, meaning the person who will take care of the property of their estate, pay off their debts, for example, collecting any debts if there are any, make sure that the specific property is passed on to the right people under the will, and so on. Okay, so the executor is the person appointed by the person who just died in their will to administer their estate. So once a person dies, their whole estate would pass to the executor, and a trust is implied, which means the executor is holding the estate of the deceased on trusts for whom? Well, for whoever is entitled under the will. And this is implied by the Administration of Estates Act 1925. Also, the running of clubs, setting up of pension schemes, charities, and so on, they all hold their funds on trusts. Revenue considerations are also relevant in trust matters, although you don't really need to know this. Taxation isn't part of the syllabus for equity in trusts. I've given you a little bit in your notes, in your lecture outline that you will see before you. I've given you the case of Levine and IRC and so on, where I'm sure you know, all of you know that you can legally avoid paying tax, but you cannot evade paying tax. That's a crime. But how do you avoid paying tax? Well, I'm sure a tax lawyer can tell you, can explain it much better, but a lot of the times the way to avoid paying too much tax is to make sure that some or all of your property is held on trusts for certain people, for setting up companies and so on. And so trusts, the concept of trusts is, as you can see, widely used nowadays. It permeates modern society. Okay. Next, we're moving on to trusts and the conflict of laws. So, what we're covering in this slide only applies to trust created in a written instrument. So it doesn't apply to trust which comes about by implication. We looked at two examples earlier of implied trusts. These are when two or more people own land together, own the same piece of land, co-ownership, an implied trust is created. Or when a person dies, their property is held, their estate is held on implied trust. So this what we're looking at now don't apply to those sorts of trusts. It applies to trusts created by the settler in a written instrument. The settler, remember, is the person who created the trust in the first place. Okay, so we start with the Recognition of Trusts Act 1987. This brought into force the main provisions of the Hague Convention on the law applicable to trusts. And the Hague Convention, which was signed in 1985 but came into force in 1992, the purpose of this convention is to establish common principles between all member states, meaning all the states who had signed the convention, so that they will recognize the trust as a valid concept. Now, when we're talking about the trust, especially trusts where which covers, let's say, a lot of land, a lot of property, not just land, but it could be property, investments, it could be spread worldwide. And so let's say a settler had created a trust whereby the trust property could be some land in Scotland, for example, some investments in Spain, and some shares in an English company, for example, and he has, let's say, appointed trustees from a firm based in England, but the beneficiaries are spread. Let's say some are in France, some are in England, some are in Scotland, for example. Okay, so the question is, if that trust is ever, if terms of that trust, for example, is ever in dispute, maybe one of the trustees is in breach of trusts, for example, or the trustees are not sure how much they're to pay each beneficiary, if at all, and the case has to go to court. The question here then is, well, the court in which jurisdiction? Should it be the English court? Should it be Spanish? Should it be in France, for example, in Scotland? So the Hague Convention it deals with these sorts of situations. And Article 6 states that the trusts shall be governed by the law chosen by the settler. So the settler, in creating these trusts in the written instrument, in the trust deed, can actually expressly say which jurisdiction he wishes to deal with this particular trust if ever there were any disputes. So he can expressly say so, or it could be implied by the circumstances of the case. And if, let's say, he doesn't expressly state which jurisdiction, then the court will have to look at the circumstances of that trust, of the creation of that trust, in ascertaining the relevant jurisdiction. And this is governed by Article 7, which said that, and this we're talking about implied here, implied circumstances. A trust shall be governed by the law with which it is most closely associated. So to ascertain this, the court may make reference to the place of administration of the trust, meaning where the trustees are based, for example. The status of assets of the trust, so where the trust assets are. If it's spread throughout, and then they'll have to move on to other references, such as place of residence or business of the trustee. The objects of the trust. Objects of the trust are the beneficiaries, where the beneficiaries are situated, and so on. And based on these few guidelines, the court will have to then decide where the jurisdiction lies. Okay, that's all you need to know about trust and conflict of laws. Conflict of laws on its own is a whole module, but it's not what you need to know here. What you need to know here, you may get asked in the multiple choice section about the Hague Convention, or Article 6, Article 7, for example. It's unlikely that you will get asked this in Part B in an essay or problem question. It's unlikely. Most likely, if at all, in a multiple choice type question.